My Lord, my Lady, good afternoon. I can help a little bit with footnoted cases in Benyon. You've got on the desk with a blue tab what might usefully now go into tab 134 of volume 12.
Right.
It's actually the case that is cited alongside the Utah case that we've got at the bottom of 6837 of Benyon about not widening the purposes of the Act. It's a case about storage of eggs in Australia. There was a regulation dealing with how eggs should be stored once the relevant marketing board had finished its function of dealing with the marketing. That was held to be ultra vires because it would have been expanding the statutory scope beyond its reach. And the key paragraphs are paragraph 4 at the end. And it was a very general provision to make regulations. You see that at the beginning of paragraph 3. But at the end of paragraph 4,
yes,
such a power will not support attempts to widen the purposes of the Act or vary the plan. And then the ultimate conclusion at the end of paragraph 12 was that they had extended the legislative plan rather than carried it into effect. I haven't got, at the moment, either Gorris or Phillips at the bottom of 6836. I do know that Gorris was sheep overboard.
Yes, it was.
And it was a regulation that was the basis of an action that failed. The regulation talked about how you had to look after sheep on board a ship. Actionable duty, no. Why? Because the purpose of the enabling statute was to prevent communicable diseases between sheep.
That's right.
It has nothing to do with any other purpose. So, but that's obviously a case that's about construing a regulation in line with the statutory purpose. Yeah. Principle of legality.
Where did you want us to put Shanahan?
I suggest we put it at the
134.
134 of volume 12.
Yep. Thank you very much.
Principle of legality we deal with at paragraph 2.12 of our printed case. It's a short point.
What is?
2.12 of our printed case.
2.12.
2.12, yes.
Thank you.
I've already indicated that this is a prior question to the question of whether a right or value has been abrogated, because that would be agreed issue number 2.
Yes.
So it's about affecting or interfering with rights or values and whether statutory language has to be clear if that is to be the proper interpretation of the statute. And we'll see in a moment, Lord Phillips thought it was closely linked to ultra vires, and you can see why. Take my example of northerners and southerners, and we do this in paragraph 2.13 of our printed case at the end. Boys and girls, non-nationals and nationals.
But they're all unhelpful analogies. I mean, it seems to me if you take absurd analogies, obviously you're making a different point, really. You're making a point that it would be, or at least it would be invalid on the ground of irrationality or complete disproportionateness. And, but on the other hand, if you were talking about Scotland and England, you're coming closer to if the tax base were separate, which it isn't, you're coming close to the present situation. But I think those analogies are simply absurd.
Take any non-absurd example, and there may be a reason why it's not easy to think of them, where you've got two people side by side who are identically placed so far as means, merits and needs are concerned.
But they're not identically placed. That's the argument against you. The point, you may disagree with it, and I think you do, but the Court of Appeal certainly thought that it was not irrational if you had made it, at least if it was covered by the language, to distinguish between those who were effective taxpayers and those who weren't.
I mean, in a sense, in this case, at any rate, it's really the second argument in different clothes, isn't it?
Well, it comes in at a prior stage. It comes in prior to justification. I will just explain why, because it's important. But I said, the way I put it a moment ago to my Lord Mance was identically placed so far as means, needs, and merits.
Then it becomes the first argument in different clothes.
Now,
doesn't it?
now to say that they're taxpayers or non-taxpayers, maybe that's a good example. Only legal aid for those who pay taxes. Anyway.
Well, that is the second question, and if you want us to answer it, we'll have to get to the second point.
It's not the second question, it's the first question with respect we submit, because it goes to the vires.
Well, I see.
Can I explain the point?
Yes.
And then, de bene esse, you can decide whether it adds anything. We say that even if you started from the position that it's a general power to amend or differentiate, it is not a power which would permit discrimination between those who are identically placed so far as need or needed services, if we're focusing on the proper meaning of services, or needy classes, if we're focusing on the proper meaning of class in section 42. I was asked this morning by my Lord Reid whether there was authority for the value of equal protection of law, and I said I was going to show you Gurung, so I will. It's volume 6, tab 50, and it's page 5068. And Mr. Justice McComb in Gurung,
5068.
case about ex gratia compensation and those detained in the Far East during the Second World War, identifies at the bottom of 5068, starting with a lecture by Lord Steyne, a theme very familiar at this altitude. The importance of the development of constitutional rights has not come to an end with the advent of the Human Rights Act. Reference to convention protection of discrimination, and then this: the constitutional principle of equality developed domestically by English courts is wider. Law and government must accord every individual equal concern and respect for their welfare and dignity. Everyone is entitled to equal protection of the law, except where compellingly justified distinctions must not be made on any race, colour, belief, gender or other irrational grounds. The judge then says, I cite that passage in demonstration of the continued force of the common law principle of equality. There's then the very familiar Matadine and Pointer. He says at 39 that leaves the principle intact, and he goes on to apply it at 55, referring in terms that Lord Bingham, we'll see in a moment, would certainly have approved as the principle of equality that is the cornerstone of our law. So that's the principle, equality, equal protection of the law. Lord Bingham, you've got in volume 12 at tab 123, at page, it won't be in the electronic bundles, too recent, but 7562 in the paper version. Middle of that page, equality before the law as a cornerstone of our society. And then the bottom of 7564, it's talking about the different positions of those with different immigration status or right of abode. One subject to removal, the other not. That's a crucial distinction. Differentiation relevant to it is unobjectionable, indeed inevitable, but it doesn't warrant differentiation irrelevant. And then Lord Scarman, famously in Khawaja, was a case about the degree of scrutiny applicable in judicial review in the case of those who were in detention. Every person within the jurisdiction, top of the next page, enjoys the equal protection of our laws. That in turn was cited in the Belmarsh case by Lord Bingham himself. Page reference 3776, volume 2, tab 17 is Belmarsh. Khawaja is page 4835, tab 41 of volume 5. So there's no doubt, we respectfully submit, that equal protection of the law is a protected value at common law. And of course, the principle of legality protects, even in the face of general words, protected values at common law. It could be legal professional privilege. It could be right to the court by way of judicial review, or it could be a number of rights that find reflection in the European Convention on Human Rights. Crucial question. Does the principle of legality only apply to an abrogation of a right, which is the second issue, or does it apply as a prior question to an interference? Answer emphatically in Ahmed, Volume 6, tab 57. Ahmed was the asset freezing case where there were instruments at UN level and EU level. There was an enabling act and then an order in council, or two orders in council, that gave it effect. And the individuals and their families, as you know, were adversely affected by those measures. Now, it's focusing, and it's sufficient to focus on the position under the terrorism order, which Lord Hope describes at paragraph 5375. There'd been a terrorism order, it affected G, A, K, and M and their families. There'd been directions to freeze their funds. And crucially, there is no finding in Ahmed at all of an abrogation of rights. The reason for that is given by Lord Phillips, starting at the bottom of 5405. It had been argued by the appellants, paragraph 91 of Ahmed, that the freezing orders violated their rights to respect for family life under Article 8, peaceful enjoyment of possessions under Article 1 of the first protocol. And it was controversial. That wasn't accepted that that was the position. Lord Phillips then goes on to say at paragraph 106 that there can't be any finding of an infringement or a violation because at that stage the law had accepted that UN instruments and the duty to adhere to them was a trump card. That's what had been decided in the Al Jeddah case. And so therefore there could be no claim of that kind pursued on the then state of the law, paragraph 106 on page 5410. So there's no finding of abrogation of rights in this case. And yet the principle of legality not only applies, it holds the day. If my lords, my lady, look in the speech of Lord Hope, with whom Lord Walker and my lady, Lady Hale, agree, paragraph 45 on page 5390, talking about the power in the enabling legislation that has been set out at 5389, paragraph 42. And the issue was all about whether you could really take these steps on the basis of reasonable suspicion and whether that was sufficient. Paragraph 45, just above letter G at 5390, the closer the measures come to affecting what in Sims Lord Hoffman described as the basic rights of the individual, the more exacting the scrutiny must become the scrutiny of the words, the general words, to see whether they really permit the measure in question. Over the page, in the middle of the page at letter D on 5391, we've got Pearson, the principle of legality, and the phrase is adversely affect the legal rights of the citizen or the basic principles on which the law of the United Kingdom is based. And at letter G, the word is interference. It does not permit interference with the basic rights. More of the same at paragraph 60 to 61. 60, that starts at the bottom of 5395. Can't use the powers to impose the restrictions on grounds of reasonable suspicion. Top of the next page, 5396, strike at the very heart of the individual's basic right to live his life as he chooses. 61, reasonable suspicion test, exceeds the powers. It's a clear example of an attempt to adversely affect the basic rights of the citizen. And that's the conclusion, as I have submitted, that holds the day. Lord Phillips agrees with it at paragraph 157 on page 5421, where he is again using the language of affect the fundamental rights of those in this country. And if you go back to 5417 in the middle of the page, and I flagged this up earlier, he makes the point that this is close to Vires, end of paragraph 138. Whether in so deciding I'm applying the principle of legality or a simple rule of construction that confines general words within reasonable limits where fundamental rights are in play, matters not. Benyon would probably say they're one in the same. And he set out the principle of legality at paragraph 111, page 5411, letter C, encroachment of fundamental rights. Lord Roger is the same at paragraph 174, letter G, for the reasons given by Lord Hope, making an order which in effect amounts to permanent legislation conferring powers to affect directly very basic domestic law rights. Lord Brown is paragraph 192, letter C, page 5429, letter C, 5429. These orders provide for a regime which considerably interferes, is his language, and my Lord Mance, finally, at paragraph 230 on page 5442, at letter F. Further, and in any event, letter F on 5442. Since the Treasury's case involves interpreting the words necessary or expedient as authorising a major inroad on the basis of reasonable suspicion alone into the rights, in any event, since it authorises those, the principle of legality, which I discuss in more detail below in relation to the other order, argues for the more limited interpretation. It is very, very clear that that conclusion is based on the principle of legality. It is not based on a conclusion of abrogation, and it demonstrates that the principle of legality is in play where there is an interference. I would accept, just to be clear, the point that's in paragraph 45 of Lord Hope's judgment, with which Lord Walker and Lady Hale agreed. That was the point about there's a range, it's contextual. The way it was put in paragraph 45 at 5390, the closer the measures come to affecting the basic rights, the more exacting the scrutiny must become. So there's a scale, but these are contextual principles.
Yes.
And I ought to just show you, before I leave the point, the way my Lady Hale had put it in an earlier case when you were sitting lower down in the Court of Appeal. It's a case called Salim. It's volume 5, tab 47. It makes that same point. It's page 5000. And the way my lady puts it in Salim, letter B on page 5000, volume 5, tab 47, I also accept the more fundamental the right interfered with, the more drastic the interference, the more difficult it is to read a general rule or regulation making power as authorising the interference. And that's with respect, we would submit, important and helpful in illustrating that one will apply this principle contextually, but it is quite wrong, we submit, to hold to the position that the principle of legality is just the same as is there an abrogation of rights. And unless you can show a violation of rights, the principle of legality adds nothing. What it adds is that there are certain context certain situations where there are interferences or serious interferences with principles, values, rights, where the court will require that the legislation is explicit, the primary legislation is clear. A good example is liberty. If you're going to detain someone, detention can be justified. Detention is not necessarily an abrogation of fundamental rights, nor is a vexatious litigant order that stops someone going to court without leave. But you have to spell it out on the face of the primary legislation because those values are so important. Our submission, therefore, is...
So what is the value which here
equal
is...
protection of law. It's equality before the law.
Well, supposing one took the view that the two situations aren't equal, don't we have to form a judgment about that? I mean, maybe in terms of the statute they are, and then you're back to the question of statutory construction. But if we took the view that it would be perfectly possible to draw a distinction, why do we treat them as equal?
Because, leave aside the statute and the scheme and the purpose. When you have, side by side, two individuals with the same rights, the same needs, the same merits, and the same lack of means, and you allow one of them to have help and the other not to have help, you are discriminating. You are taking a measure that interferes with their equal protection of the law. And if you're going to do that, the primary legislation needs to spell that out. And that, the word class certainly doesn't do that, and nor does the language of Section 9. Now, finally, my lords, before
reading through that, it seemed to me that Ahmed was a very long way away from this case where you've got a provision which actually is stopping someone conducting his normal life. There's nothing like that here. And I thought it's much more relevant to your argument what's being said in cases like Kawaja and Belmarsh, that prima facie British laws apply to everyone within the jurisdiction.
Yes.
And so if that's going to be departed from, you expect to find clear words in the statute doing that.
I respectfully
It seems to be much more specifically relevant to this case. Than
I would respectfully agree. And you've seen the Law Society put in a case which they make several points, but one of them is strongly advocating the equal protection of the law at common law. We respectfully agree and endorse what they've said. Can I just enter 2 points on the principle of legality before I sit down? I'm not arguing either of them. Mr. Bowen has made submissions that are specific to children. Because my case is about the generality, I'm seeking to protect everyone. I do not adopt those, but there they are. I do adopt Ms. Rose's submissions that are of general import. So far, if you were to get into international treaties and human rights, there's quite a lot to say about the principle of legality on that. It's not argued, it's not before you, and I simply, therefore, would, for myself, would want to flag that up. It wouldn't be right not to do so. The second point is this. It has been said that there are constitutional values that are so fundamental that even primary legislation would give rise to questions as to their protection. And the example that's usually given is the abrogation of judicial review. I would want to reserve my position as to whether now is the time in the constitutional development of public law in this country to recognise that there are constitutional values of that kind and that even primary legislation is subject to a principle of constitutionality. But it doesn't arise in this appeal. I simply wouldn't want to be misunderstood. I make no concession as to what could be done by primary legislation, even at common law. Subject to those 2 points, and unless you've got any further questions or I failed to answer anything that was put to me earlier, those are our submissions on agreed issue number 1, and I don't say anything for now in relation to agreed issue number 2.
Thank you very much indeed, Mr. Fordham. Thank you. Mr. Jaffe. Mr. Reedy.
My lords, my lady, a couple of things to start off with. First of all, in relation to Article 9, I'm not going to trouble you at any length at all with Article 9 of the Bill of Rights, but it might be thought that the example on which you wish to invite the court to look de bene esse and take his principled stand was not the greatest one from Mr. Fordham's perspective in relation to that issue. There is some debate in the case law about precisely when Article 9 does cut in and when it doesn't. But by and large, and in grotesque over-summary, the thrust of that case law is that if you're referring to parliamentary materials, as it were, uncontroversially to illustrate history or fact, or sometimes under Wilson and First County Trust purpose, that is one thing. If, on the other hand, you are effectively inviting the court to look at a committee of Parliament or what was said in Parliament for the purpose of espousing the view, then that is much more problematic, and it's much more problematic for the reasons set out in the Parliamentary Council's correspondence, and indeed in some of the case law, OGC, Justice Stanley Burnton as he then was, because it invites the court into territory of questioning. If someone says, it's either questioning or fairness, you either, so JCSI, if they say we're doubtful about the Vowries, I either have to say we don't agree, brackets questioning, or I keep my mouth shut because of Article 9 of the Bill of Rights, brackets unfairness. So you perhaps don't need to address those issues a bit as the Court of Appeal didn't below, because I suspect that in the end Mr. Fordham was prepared to move back from that position. So that's all I say about Article 9 of the Bill of Rights. At some point, no doubt, it may be important for this court to clarify its reach and scope, but where the case law currently is, as I say, is broadly on that divide. Secondly, we've done a very short riposte to the Law Society's intervention in this case. I'm not going to take you through it in any detail here, and it may be that it's as much relevant to issue 2 as to issue 1, but it does, if it does nothing else, it does, we hope, relevantly cite My Lady and Webster on the principle of what equal protection before the law means, and perhaps unsurprisingly, My Lady has concluded that it requires that the laws themselves be equal. The problem she then identifies is that sometimes laws do have to and do indeed treat people differently, and the question then becomes one of justification. So ultimately, whilst no doubt attractive and resonant to keep repeating equal protection before the law, ultimately the submission is that that is question begging, because the issue in any particular case will be whether or not the particular groups that you are comparing are generally are properly comparable. The Strasbourg, are they in analogous situations? Question. And or, and sometimes they drift into one another, are those differences of treatment, is the differentiation that the law has created justifiable? Perhaps unsurprisingly, given that the first argument is an ultra vires argument, I want to start, if I may, with the scheme of the primary legislation, and just to make some points in relation to that. The Legal Aid, Sentencing and Punishment of Offenders Act 2012 is behind tab 1. And you see, just flicking through it very quickly, section 1.1 creates the basic obligation on the Lord Chancellor to secure that legal aid is made available in accordance with this part. In the civil context, legal aid is defined by section 1.2 as civil legal services required to be made available under section 9, relevantly, or section 10. You can leave aside para 3 of schedule 3 for this purpose. You see that in 1.2a. And the broad scheme of that requirement, or that entitlement to legal aid, is then dealt with in sections 9 and 10, to which we will come. But you see that civil legal services are defined in section 8. And you see the various ways in which the types of services that comprise legal services are set out. Expanded in 8.2, and then you see that the concept of civil is dealt with in sub 3 of section 8, other than criminal, effectively. So if you're dealing with the type of service in question, section 8, and you're within the description of subject matters in schedule 1, then the Lord Chancellor must secure the availability in accordance with section 1.1, which itself referred forward, as you will recall, to section 9.1. So 9.1 and 1.1 are to be read together, effectively. And what 9.1 is doing is to determine and set the entitlement to legal aid. And it does so by reference to the civil legal services being included or described in Part 1 of Schedule 1, and the director making a qualification determination and those determinations, by and large, have two features. One, they deal with merits and means. So Section 11, just to jump forward, which you've focused on, I know, deals with merits and requires individual case determination of merits. So Section 11 is not setting the boundaries of entitlement to legal aid beyond recognising that regulations can be made that effectively deal with merits and then requiring individual case determination of them. I'll come back to this, but it won't surprise you to know that we don't, not merely have we not relied upon Section 11, but we do not rely upon Section 11 for the purpose of providing the voucheries for the broader setting of the essential ingredients of the scheme. And we don't rely upon that section, firstly, because it deals with merits, effectively. And so we would agree with my Lord Toulson that when there is a reference to public interest at the back end of the factors that are identified in sub 3, that must be read consistently with and as part of the factors that precede it. It doesn't provide a freestanding public interest justification, but all of those matters are to do with individual merits. And so they require individual determination, as you see from 11.1, whether an individual qualifies under this part, in accordance with the criteria and the means point, which is Section 21. And you couldn't, therefore, make no sense to introduce, as it were, a residence test under that, because you determine in every case which fell within the residence test.
So I understand that 3, the criteria, are general. 1 is obviously an individual determination, but the criteria that you set under 3 take into account all sorts of general factors.
You can, but in the end you then require individual case determination.
You obviously end up with an individual decision, but the question is, what are the criteria do you apply? And they will be determined on a general basis.
Yes, but although they're general, they're also directed to nuancing in individual cases. They are by and large to do with merits. 11 is to do with merits.
But shouldn't you read it with Section 41(2)(b), which enables provision to be made by reference to services provided for a particular class of individual? Doesn't that go with Section 11?
My Lord, no doubt it could do. My submission is going to be, when I come back to 9, that 41(2)(b) can be read in relation to both of them. So it can be read, it has to be read together with Section 9 and with Section 11. But fundamentally, 11 is dealing with the criteria that are to apply when you're doing the cost-benefit analysis, that is the legal aid individual case determination. I'm not excluding the possibility that you could have a particular class of individual. They could be set by reference to that, but it is fundamentally directed at setting the criteria by which that individual case determination of merits falls to be dealt with.
You say it isn't seeking to exclude or include any general class. It's asking you to take into account certain general factors when considering whether the particular claim should be...
That's the structure of it, and that's unsurprising once one recognises that you're dealing with merits.
Yes.
But I don't understand that. I mean, you could easily have had an extra criterion whether he has a sufficiently well-established connection with this country. And that would have been a criterion, and the Secretary of State would have to say how that worked out in practice. Yeah. But there's nothing illogical in there.
It could even have come in under 2A. In setting the criteria, the Lord Chancellor must consider the circumstances in which it's appropriate to make civil legal services available under this part.
Including the connection with this country.
Yeah, I mean, well, but B is only in particular. I don't suppose B is exclusive.
Oh, yes, but I mean, as I say, the view has been taken that Section 11 does not warrant setting these sorts of criteria because it is directed to other matters. The other thing to bear in mind in relation to Section 11 is that it is only if you're altering Part 1 of Schedule 1, in other words, it's only if you're altering that scope, part of the Act, that Section 10, which I've jumped over but we'll come back to now, that Section 10 applies, namely the exceptional cases. So the broad structure, as you see, just go back to 9.1 for a moment. I'll come to the enabling power in a second. Just go back to 9.1. That's the entitlement, and the director's determinations are to do with the merits matter and the means.
Determinations are individual, obviously, in each case. It's not that, is it? It's the fixing of the criteria, which might extend further, but you are firm in your view that it simply doesn't.
My lord, we are.
You're accepting, I think, that while Parliament might itself have cast 11.3 differently, it's chosen to cast 11.3 as it has, and that those factors collectively provide a fairly clear pointer to the sorts of matters which should guide the Lord Chancellor in setting the criteria, and that were he to introduce a residence requirement under that, he'd be stepping very much outside that territory.
My lord, I do say that. I put it less elegantly than that, but I do say that, and that is so irrespective of whether or not one could cram potentially within the literal meaning of 2.
Right.
The residence test.
Sure.
One's got to construe provisions in their proper context, and that requires looking to see broadly and generally what Section 11 is about.
Yeah.
Of course, I accept that individual case determination at one level, regulations set the broad criteria against which that is to be judged, but the question is whether you could use it for that purpose. And I also emphasise, I say, that it is important in construing the breadth of the power in Section 11 that if you were to use Section 11, you would necessarily lose the exceptional cases protection that is integral to the protection on human rights grounds of this part of the legislation, which is itself another factor of some importance. But you see the basic structure. So you've got entitlement under 9.1, come back to 9.2 in a second, and you'll see the heading of Section 9, general cases. So that's generally how you get legal aid. But the Act also makes provision for what are termed exceptional cases in Section 10.
I suppose the answer is you could get them back. I mean, this is all perhaps a bit theoretical in view of the common ground, but you could reintroduce them under the criteria, couldn't you, exceptional circumstances?
Well, that would raise an interesting question.
Leave this aside.
Forgive me, my lord, it would raise the question as whether or not you could reintroduce into the regulations by secondary legislation that which Parliament has advisedly only allowed in the limited circumstances of Section 10.
I see.
So that would, I mean, I'm not saying you couldn't do it. I never shut the door on the possibility of doing it, but, those are the reasons why that's problematic. And of course, the reason I go there, you'll understand, is because, and I'm going to come back to the basic argument, but the matter that's evidently concerned the court this morning, and that caused my heart to sink when you told me you were dealing with Varies first, was that Section 9 can be taken as effectively creating a bifurcation. You've got civil legal services and you've got qualification, and there the twain shall meet, and therefore when you get into 9.2, it's civil legal services only. So it's quite relevant to know what the scope of the power under 11 is. But I was on 10. 10 you will see...
Sorry, before we leave 11.
Yeah.
Looking at section 12.1, I think it's implicit in that when we see that a determination must specify the type of services for which the individual qualifies. The implication of that seems to be that qualification under section 11 isn't a blanket open sesame for all the legal services in part 1 of schedule 1, but it could be more nuanced than that.
Yes, it could.
Yeah.
Well,
yes, it could.
The certificate defines what you get your legal aid for. It always has.
It always
And
has.
it still does.
And it no doubt always will. But you'll appreciate as well, without jumping too far ahead in the argument, that Schedule 1, as it were, uses a variety of techniques for defining services. it's got subject matter, and it's got the nature of advice, assistance, representation, whatever it may be. So there are a whole variety of different techniques going on. It's very tempting to just look at services and say services means the subject matter or it means the representation. In fact, it covers a pretty broad church and isn't, as it were, to be confined in that way. Sorry, back to 10, to try and keep it within at least a sequential and logical order. You will see that the guts of 10 is that, and that's why it's no doubt described as exceptional, the guts of 10 is that even if you are outside Part 1 of Schedule 1, there is a requirement to provide legal aid in the circumstances set out in 3. And the circumstances set out in 3 are that the non-provision would be either a breach of EU law or ECHR law, or that there would be a risk of such a breach rendering it appropriate. So that's the distinction between 3A and 3B. Do you see the word necessary and then breach in A, and appropriate and risk in B? That's the essential.
Going back, because Section 12 was raised and the time point, there is some indication in the explanatory notes about that, 3328, which I think would support what you are saying, that paragraph 118, going to subsection 1, gives the illustration for type, for example, advice and assistance,
Yes.
and for what the service will be available, for example, JR.
So subject matter and nature.
Yeah.
Yeah.
Can I just refer you briefly, because it's helpful to understand how this overall structure works, and helpful also, you need to understand this bit of it, because lots of my learned friends' submissions, and I'll come to this specifically in due course, have been based on the premise that we are here dealing with not merely a Henry VIII clause, but the principle of legality, and therefore, even if it's a principle of degree, the more serious the breach, the more interested you become in a narrower construction, if I can put it that way. But what he has failed to confront is that this legislation already requires, irrespective of the arguments about the scope of Schedule 1, already requires that if there would be a breach of ECHR rights or there would be a breach of EU law, legal aid is still required. So you can mess around with Schedule 1 as much as you want, but you cannot escape from the coils of Section 10. And what that means is that we are here dealing with the rules that should govern the provision of, if I can put it this way, non-obligatory legal aid. And that is given added force, whether one views it as a matter of domestic law or one views it as a matter of ECHR or EU law, it matters not. It's given particular force because, as you will be aware, and as I'm about to show you from Gradan Vicien, the Court of Appeal decision, which has considered Section 10 and the guidance made under it, the ECHR and the charter rights under EU law directly replicate this, requires the provision of legal aid if you need legal aid in order effectively to present your case without obvious unfairness. So you're necessarily, therefore, dealing with the bounds for the provision of state subsidy outside that category of case. So in cases where you do not need legal aid for the purpose of presenting your case without obvious unfairness and effectively. Gradan Vicien is at bundle 7, tab 67, 5734. And again, without going through the detail of the head note, this was effectively a challenge to the lawfulness of the guidance that the Lord Chancellor had issued in relation to when and how sub 3 of 10 should work. And in a nutshell, as we will see in a second, what the Lord Chancellor had done was to use a variety of different adverbs and adjectives to demonstrate to those making these decisions on the ground that it was only going to be in a very rare case, or rarely or exceptionally, that 10.3 would operate. And so the Court of Appeal reviewed in considerable detail the Strasbourg case law for when legal aid is required and the EU case law, and concluded that that had been overstated, and therefore the guidance was not lawful and needed to be revised. You will see the sort of quotations that I've just described recorded in paragraphs 13 and 14 and 15 of the judgment, 5745 on the electronic. But so you only need a flavour for the purpose of understanding what the case was about. If you look between B and C on page 5745, rather the European Court has recognised that there are very limited circumstances. Go to the last sentence of that little quote, as set out below, the threshold for such breach is very high. Next paragraph in the quote of paragraph 12 of the guidance, in certain very limited circumstances, second sentence of that little quote. Practical impossibility, you see underlined, obvious unfairness, very high threshold in the quote in 15. So that was the nature of the challenge. They concluded that no assistance was in truth to be derived from the heading of exceptional cases in 10, effectively concluding that exceptional was to be contrasted with general as the heading for section 9, rather than as indicating any form of test, as you see from para 29. They then consider the risks of breach in the statutory language in 31 and 32 and reject both the real risk of a breach and the high level of probability of a breach, and say effectively the language of 10.3 needs to be applied in accordance with its pure and natural language without any glossing of that kind. And then they move on, as you see from the title above 35, to an extensive analysis of the ECHR jurisprudence. You see that at the top of that page on 5750, is the guidance compatible with Article 6 of the Convention and 47 of the Charter? They effectively held that they were the two were the same, so there was no difference between EU law and ECHR law. They go through a variety of the cases. And then 45 sets out their view you see them summarising the language that was used in the guidance at 44, and they conclude that that's too high. In other words, that the scope and reach of the exceptional cases in section 10 is broader than had been suggested in the guidance that the Lord Chancellor had adumbrated. What is the test under Article 6? You get that most clearly and most pithily expressed in paragraph 56 on page 5757.
And that's general, is it? Whatever the subject matter of the dispute. At least if it's the determination of civil rights and therefore within Article 6.
The subject matter will
play into the Article 6 analysis.
Into the critical question of whether an unrepresented litigant is able to present his case effectively and
Yes.
without
Yes.
obvious unfairness.
Yes, of course.
and indeed importance to the individual and so on. I think there's quite a, I mean,
understand.
I've taken it very shortly. I suspect that that's a summary rather than a full encapsulation, but if you wanted a slightly fuller version, they effectively accept that the correct way of looking at the Article 6 test is to apply the ARI, the well-known 1979 ARI in Ireland standard, and they quote the relevant passage, quite a long passage, in para 35.
And then 46, I think.
Yeah.
Yes?
Yeah. So, but that gives you a flavour. So too high to say it's got to be rare cases and so on. And the significance of that for the purpose of the interpretation of this legislation and of Ari's question is that there is already coverage for these sorts of cases. If the case cannot be presented effectively and without obvious unfairness, legal aid has got to be provided irrespective of the breadth and scope of Part 1 of Schedule 1. And that provides, we respectfully submit, a perfectly coherent and sensible point for the argument that this court should not contort or restrict the natural breadth of the language that Parliament has chosen to use in 9.2, and it goes to the weight of the purposive factors that my learned friend has identified by reference to Padfield and other principles, and it goes to equality before the law, if that is truly a freestanding point of principle. The powers in question, then, just to go back to the primary legislation, Section 9.2, you will have seen the Lord Chancellor may, by order, vary services described in Part 1 of the schedule, whether by modifying Parts 2, 3 or 4 of the schedule. The basic intent we submit of the legislation is to set up the structures, who administers, how it's to be administered, setting up a system for general and exceptional cases in 9 and 10, but to allow for a degree of fluidity and flexibility to be dealt with by secondary legislation in relation to the precise scope of what is covered. And my submission is that section 9.2, can be read and does have to be read alongside section 41.2b.
Now, am I right in thinking that you say that 41.2b, they may make provision by reference to services provided for a particular class of individual, is synonymous with by reference to particular classes of individual for whom services may be provided?
Yes.
Has there ever been in this country any residence test for legal aid of any sort, criminal, civil, and is there any analogy you can think of in other legislation where a residence test, I mean, social benefits, one knows, have got certain residence tests in some contexts.
Yes.
Entitlement to be here, right, and so on, has been controversial. But what about legal aid and anything directly analogous?
I'm not aware of anything directly analogous, but
one might have thought, which is the underlying thinking, that it's a pretty fundamental point, which is the sort of point, if one's permitted to think this, which would have merited full debate and in the House of Commons and House of Lords.
Well, my Lord, that's why I spent a bit of time going through the exceptional cases bit. And as I say, there's a slightly kind of artificial distinction at certain points of the argument between issue 1 and issue 2.
Yeah.
But
as you say, exceptional cases, they are covered.
they're covered. And what that does is to render the analogy with those non-legal aid situations that much closer.
Yes.
Of course, one sees the visceral force of the point that says, you know, there you are, I've got the same sort of case, and one person gets legal aid and the other person doesn't. But once you appreciate that the core cases in which that could cause obvious unfairness...
Where our international obligations are engaged, they're all covered.
Quite, they're all covered, but not merely that, but you are then dealing genuinely with the removal of public subsidy funded by the taxpayer from non-essential legal aid services in that sense. And that does bring the analogy much closer. There are cases in the bundle. I don't want to reopen old wounds by referring at this point to Tigère, but Tigère is one in relation to education, which caused a little division amongst members of the court. But as importantly, and perhaps more directly for my Lord's purpose, there are cases in the bundles, and I will find it in 1 second, which deal with the provision of free healthcare. I think it's called A. Just give me 1 second and I'll find it. Thank you. 656. Thank you very much, Mike. Uh, 5271 for my lady's computer if you want it. But paragraph 5278. I'm not compelling you to go there. But,
You did sound a little bit dismayed.
forgive the impertinence. Paragraph 15 shows you effectively what the health service regime looks like.
Yes.
So you have got a number of examples of which health is a pretty decent one, where one rule applies and the other one to residents and doesn't apply to non-residents.
But I mean, that's because it's in the statute.
Yes.
If one goes to section page 5277, you have a statute provision which says you can provide for people who aren't ordinary residents.
My Lord, that's true in the primary legislation there. I'm not, this isn't so
I
much...
mean, because I mean, the sort of basic principle that we see in some of these cases, Coard and so on, that a British statute applies to all those within the jurisdiction. It's a normal starting point. And if that's going to be departed from significantly to exclude a section on the grounds of lack of residence, you would expect to find it in the Act.
But you wouldn't necessarily expect to find, I respectfully submit, something which there is no mandatory rule that says that has to be done by primary legislation.
Well, isn't there? I mean, I'd be surprised if you can find any example of a case where something like this has been done, that we see in this case, in the A case, without primary legislation. Well, if you can find one, I'd be very interested to see it. But
This is where it seems to me there is a point here of some real constitutional importance. You stress the breadth of the language of section 9(2)(b) when read alongside 41(2). It might be suggested that the breadth of the language is two-edged. We've had Benyon cited. I was looking out of interest to see whether there was any relevant comment in Daniel Greenberg's edition of Craze, with which you'll be familiar as a text. He's got quite a lot about Henry VIII clauses and suggests, you won't agree with this at all, but suggests that although Henry VIII's powers are often cast in very wide terms, the more general the words used by Parliament to delegate a power, the more likely it is that an exercise within the literal meaning of the words will nevertheless be outside the legislature's contemplation. That's paragraph 1(3)(11).
Right, well, we might need to be a little careful with that, because it tends to the proposition that you're damned if you do and damned if you don't.
Well, but you see, it does then raise the question, what actually is the focus of 41 2B, when it talks about services provided for a particular class of individual, you say that it's just the same as if it said may make provision by reference to classes of individuals for whom services can be provided. And therefore you can say, well, we'll remove individuals who come within this, that, or the other category. That might be thought to tilt the aim, the balance, and that if that is so, then the fact that it can be put within a literal meaning of words may not be sufficient for you.
Well, yes, you have to read it. You have to read it with section 10 as well.
Yeah.
You have to read it with section 41(2)(c) as well.
Yeah.
To test the proposition, and you have to take into account the overall structure of the legislation and what it is doing.
That's true. But the Court of Appeal, certainly, I mean, they saw 41(2)(b) alongside 9 as the key which unlocked.
Yes. And in my respectful submission, they were right to do so, because if you look at the broad structure of the Act, what this enabling power in 9.2 is doing, when read with 41(2)(b) and taking into account 41(2)(c) as well, is to enable those services to be added to, varied or omitted. And the question is, how and by reference to what can that be done, ultimately? I mean, you're not talking about a pure service, you're talking about already subject matter in the sense of the nature of the litigation, and you're talking about service in the sense of the provision of advice and assistance or representation or whatever. The question is, how has Parliament decided that this power could be exercised in order to create a change to those structures? And the answer to that, we respectfully submit, as the Court of Appeal rightly identified, was to go to 41(2) and effectively to read in, because that's, on any view, a set of indications as to the breadth of power in 41, a set of indications as to the breadth of power which applies whenever orders are being made under that part.
Yeah, I mean, but it is reading in a part, which is really picking up Lord Carmel's point, which is saying that Parliament has in mind there that you can differentiate between different classes of people lawfully within the jurisdiction and affected by the same laws and with the same need. And one looks to see, well, now, is there any pointer in the Act somewhere which indicates that these very broad words are intended to embrace that type of provision?
Well, my Lord, I'll come to make the submissions in a second on the breadth of that language, but my submission is that those words are certainly general in their effect, a particular class of individual, and broad, if you wish to characterise it that way, but they define the mechanisms that can be legitimately used, that Parliament has decided can be legitimately used when changing the scope and reach of the core structural provisions in Schedule 1, Part 1. And they've gone out of their way to say you can do it by reference to a particular class of individuals, or you can do it by reference to selecting them by reference to particular criteria. So although if one's hunting for the snark, as it were, if one's looking for something that says, and by the way, you can do this on the basis of residence criteria for cases that are before the courts, there is nothing of that kind. But those words, I respectfully submit, are general in one sense, but very specific in another. They're directly targeted on the mechanisms that can be used for changing this. And bear in mind, I know the Court of Appeal were not impressed on a slightly different point with my affirmative resolution point, but it does sound here, when one is considering Vari's, ultimately Vari's arguments are about the extent of legislative authority.
Yes.
And if you have, as you did in Ahmed, for example, a piece of legislation which allows orders to be made that are not subject to parliamentary scrutiny at all, because they're simply orders in council, that is one thing. But what Parliament has done here is to break down the sort of scrutiny that it has decided in the primary legislation, it has decided should be afforded to each of these changes. And so when you go to 41, if you just go back to 41 for a moment, 41 isn't just interesting because it has sub 2 in it, it's also interesting because it has sub 7 in it. or sub 6 and sub 7.
Yeah. Yes. You
So
mentioned-
you see the default rule is in 5, negative resolution, and then some types of change, some exercises of authority. Parliament in the primary legislation has said, we want the greater scrutiny back to us.
As I see that, your argument about affirmative resolution might be thought to prove too much in this sense. Again, Greenberg's right. Affirmative resolution is standard for Henry VIII clauses. If that be so, and then if the fact of affirmative resolution has the consequence for which you contend, it would follow that all Henry VIII clauses just get a straight literal interpretation. And the broader they are, the more the minister can do. And I'm not sure that may not be going too far.
Well, my lord, I see the force of that. I mean, we'll come to Sparth Home and authorities of that kind where the House of Lords have considered these sorts of issues in the past. There is at least some suggestion that there might be a difference between, or a distinction between negative resolution come back and affirmative resolution come back for that purpose, perhaps unsurprisingly, because the one confers a greater level of authority. So if I was answering my lord at the level of principle, of course I accept that if pushed too far, it would tend towards proving too much. But the fact remains that Parliament has decided how much legislative authority to confer. And the vice with general wording and over-construing, as it were, when you're impinging on important rights and so on and so forth, that has, and the various questions, have certain force.
I mean, I think fundamental rights, maybe putting it too narrowly, expectations, I think, maybe putting it there. I mean, there are certain parts of which are really regarded as pretty standard ways in which our law operates. They don't necessarily have to be couched in terms of fundamental rights, but that everybody who's lawfully within the country and subject to the same laws is treated the same way is a fairly basic assumption.
But they're not. They're not. I mean, even that basic premise in the context of this legislation is not sound, with respect,
Right.
and it's not sound because everyone is not treated in the same way. You have no right, if Witham is correct, and no one has challenged the correctness of Witham.
Yeah.
You have no right to legal aid.
No.
You have certain defined rights not to have your access to court unduly restricted, but there is no right to legal aid under common law, see Witham. There is no right to legal aid under Strasbourg law. And so inevitably, some people get it and some people don't. The question
I was
is...
suggesting the contrary. I was suggesting that people who are in the same situation are one would ordinarily expect to be treated in the same way, and that if Parliament envisage a minister changing it, but that's a point that's already been made and you're well familiar with it.
Yes. And my lord, my answer to that is that drifts very quickly into issue 2 and justification.
Yeah.
Back to Baroness Hale's statements in the that we've cited in our Law Society response document.
I mean, it is oversimplifying it, but if you think about distinctions between our world and the ancient world, one is that St. Paul could say "Quibus Romanus sum," and he wasn't subject to the laws of the country where he was living. He was entitled to be tried under his own system of law, which he carried around with him. And our country isn't like that. Everybody who lives here is subject to the same law. That's a presumption. And so that's why this comes as a bit of a... One wonders whether this is really what Parliament had in mind.
And everyone is subject to the same law. This is exactly the point that Baroness Hale was making in that case. The laws treat people the same, and to the extent that they treat groups of people differently, whether procedurally or substantively, that requires justification. But to say there's I think what my lord is putting to me is that there's a visceral judicial reaction, as it were, against the portable sets and different rules. But my respectful submission is that this legislation is designed to draw coherent, sensible and fair rules around when legal aid does have to be provided and when it doesn't.
I'm not suggesting there's a visceral judicial reaction, but it's the point that Lord Carnwath made, that this isn't usual in our legal system.
My Lord, it may not be, but it is usual to set the boundaries of legal aid. It is usual, there's nothing unusual about saying, here's the basic scheme of the legislation, here are the situations in which you, as a matter of system, in which you do and don't get it, including the protection for Article 6 rights in EU law. We will set those broad structures subject to recognising, and it's Parliament in primary legislation that's doing it, that as long only as you come back and we have affirmative resolution which enables us to see whether you're going too far or not, you can alter the Schedule 1 criteria. And all that is doing is saying that a greater or lesser class of person will or will not get access to legal aid. So, my Lords, my submissions on the language of that legislation and on the structure of the legislation are firstly that the language is broad and clear on its face. The natural meaning of the words indicates a broad power, not fettered in the way in which my learned friend suggested it should be fettered. And not, as it were, containing the restriction or the qualification that because it refers to services in some way, shape or form, it's out with the wording, which was the thought that was put on 2 or 3 occasions by the court this morning to my learned friend. I've seen horses reluctantly dragged to water to drink, but when my learned friend eventually accepted that what was being put to him on the 3rd occasion was a case he quite liked the look of, the problem and the reason he was reluctant, we respectfully submit, was a correct concern, which is that once you get into 41.2b, he doesn't have a very good answer as to why a particular class of person would not be entirely apt and obvious to cover the sort of situation that we're dealing with here. But the language, we say, is broad and clear on its face.
He has got an answer. You may or may not be right to say that it's not much good. But what he says is that the particular class of individual means classes of individual who have specific needs for legal services. That's what he says.
My Lord, he does, and I'm going to come to address that directly, but I was concerned to devote the first part of the submissions, at least, to the matter that which seemed to be troubling the court, which was whether or not I can even get myself within the wording. Is there some natural meaning against me derived from the combination of Section 11, which provides a flavour or an indication of what 9.1 and 9.2 are about? But you have my submissions on that. It's effectively that 9.1 is just dealing with entitlement, and that 9.2 needs to be read sensibly and coherently with 41.2b and indeed c, and that, as the Court of Appeal found, does provide that. And the correct approach to these sorts of matters is to be found by looking at the natural breadth or the natural meaning, first of all, at least as the starting point or possibly the end point. You look at to derive parliamentary intention by reference to the words that Parliament has chosen to use. It's a staggeringly obvious proposition. If you needed authority for it, my Lord the President in Williams, I'm not going to take you to it, but at paragraph 72, we've cited it in our case at para 22, and if you want Williams, it's bundle 7, tab 76, 5705. Relevant paragraph is 72. But then also the Sparth Home case. If you go to bundle 2, tab 16, 3665 in the electronic.
Thank you.
And unsurprisingly, we don't take our stand on any, as it were, formalistic distinction between the Padfield principle and ultra vires. no doubt when construing legislation just as much as when exercising general powers, that you have to act consistently with and so as to promote the purposes of the primary legislation. The question, as Lord Bingham points out at 3697, just by the letter F, is to ascertain the statutory purpose or object which the draftsman had in mind. And the starting point, as he says, must be section 31. In other words, you go to the language of the legislation. And then you effectively ask, if you just read through the way that that analysis then pans out thereafter, if you flick over to 3698 by the letter B, and you see what he says just above the letter C. So he looks at the language, first of all, and he says, well, what does that mean? What's the natural breadth of the language used? And then he says, but because the Act covered a number of aspects of the landlord and tenant relationship, one cannot discern any specific unifying scheme in the legislation. And again, that's got echoes here, which I'll come back to. I do not find, studying the language of section 31, which is obviously treated as his starting point, that it is in any way ambiguous or obscure, or such as to lead to absurdity, if given its full apparent effect. So that's his basic approach. And for good measure, just to pick up the point while we're here, he advocates against what he describes on 3701 between E and F. He warns against, on the back of Lord Simon and Lord Diplock in Mansell and Ollins, a simplistic approach to construction based on an assumption that the draftsman had sought to remedy one mischief only. In other words, that the Act has only one statutory objective. You'll recall the issue in that case. Was it only to do with anti-inflationary measures? And then see the nature of the quote with which he is agreeing between F and G. And he effectively applies that principle in reaching his conclusion, as you see from 3707, the first paragraph on the page, where he comes back to precisely that and identifies that as the vice in the argument being run by Mr. Bonney in that case. So you start with the natural meaning of the words and you ask then effectively, does that lead to ambiguity or obscurity or absurdity? And you apply that approach just as much in this sort of case as you do in any other case. And here we've seen that the Lord Chancellor can, by affirmative resolution, so it's Parliament effectively that has the decision-making function, vary, add or omit services, and can do so by reference to a class of person. So what my learned friend then has to argue for, as Lord Justice Laws noted at para 23 in the Court of Appeal, is that particular class of person is to be limited by reference to the needs of class members alone. So you have in effect to imply a limitation into particular class of person, so that it is constrained by the needs of those class members alone. And he has to assert...
It's defining those who, as I understood his argument, I may be completely wrong, it's being used to define those who are seen as having a need for the service in that particular context.
Yes.
So it can define that victims require the service rather than alleged aggressors. It can define that a particular sort of occupier has a need for the services or not. So it's the persons in relation to a particular service. That's what he's saying, as I understand it.
My lady, he is, and we don't deny that it has the capacity to operate in those circumstances.
Well, that's how it's been used
Yes.
up until this
Right. The question is whether that's the limit of it.
is the question. Yeah.
Yeah. But so, and what I'm pointing out is that if you are going to define it as limited in that way, that does require the introduction of some form of limiting concept into a particular class of person.
I wonder, does it require much more than the noscatore sociis idea? If one looks at Part 1 of Schedule 1, one finds all sorts of classes of individuals, victims of domestic violence, severely disabled children, so on and so forth. There are a lot of examples one can find there of classes of individual. And Mr. Fordham's point is that they are people with particular needs for legal services.
They are. And the question is whether the fact that, I mean, leave aside the point that some of them may go a bit beyond need, there are 31, 1, 2 and 3 points, which I'm not going to develop at any great length, and leave aside the question as to what the concepts or boundaries of the concept of need for this purpose are.
Yes, I'm wondering, would it not be legitimate to look at at what Parliament has enacted as giving us some clue as to what they had in mind when they talked about class.
But that would only work, my lord, I respectfully submit, that would only work if you were, you're effectively, you would be implying from current use future limitation.
Yeah. Yes.
And my respectful submission is that what you should be focusing on is not necessarily how the power has been exercised in the past to make changes, or indeed how Parliament originally decided to set up that scheme, but you should be focusing on the breadth of the language that enabled change to be made. Yeah. So the mere fact that Parliament has set it up in a particular way should not and cannot, I submit, be taken as being, as it were, impliedly limiting of the broad words that they've chosen to use in setting up the enabling power, because it's that dictates the ability to change. So that's the first point. The first point, taken rather at some length, is a very straightforward point about natural meaning in its proper context and having regard to the structure of the legislation. Secondly, I do submit that there isn't any good constitutional reason for giving the language anything other than its natural and proper reach. And the first point to be made in relation to that is the one I've made earlier, which is that this legislation on its face requires any such change to be brought back before Parliament by the affirmative resolution procedure. And there is jolly good constitutional reason. This is a flip side, if you will. This is the other side of the coin to margin. This court has consistently held that when you're dealing with affirmative resolution procedure, a broad margin or a substantial degree of respect is to be accorded to Parliament. But here one has got the affirmative resolution procedure, which recognises that in the scheme of the legislation itself, that Parliament itself will decide, because both houses have to agree, that these are changes appropriate to be made.
Well, we give great respect to Parliament in certain situations when on issues of judgment as to what is proportionate and so on. But do we give great weight to Parliament's view as to the scope of power under which it's acting? I don't know of any authority for the proposition that Parliament...
that's not quite your point.
That's not quite the point I'm making, and maybe the analogy is not, or the flip side is not quite as close, but I had in mind the idea that one of the underpinnings of affording margin to Parliament in that situation, you have the two strands that underpin, as we all know, the institutional suitability, who should be the primary decision maker, expertise,
yes, right. I mean, I see what you're the way
and democratic accountability.
You say that we can trust them with a wide power which they've given themselves because they've given themselves the power to review its exercise.
I don't even say we can trust them.
We shouldn't be frightened of giving it a broad
Yes.
meaning.
Exactly so, because the democratic and constitutional constraint
Yes.
is hardwired into the primary legislation. That's the point.
Well, I think you go further than trust, don't you? You say this is what they've told us
Yes.
to do.
Yeah.
You say.
Yes, but I'm trying to meet an argument that says there's some awful kind of constitutional deficit here, which should lead you to adopt a narrow interpretation.
Well, how does that reconcile with Lord Toulson's point, which is that affirmative resolution is thought to be a requirement of, or introduced in relation to all Henry VIII clauses?
Well, I've no
Seems
idea
to
what-
run in the opposite way to Lord Bingham in Strathhome and his approval of Lord Donaldson in the earlier case.
Yeah, and I don't know whether that's right or not, in fairness, and there's certainly no requirement, of which I'm aware, legal requirement, that should be the position. Whether conventionally that is what Parliament has done, I don't know. But even if it was, that doesn't undermine the force of the point, which is that Parliament will ordinarily, or perhaps always, decide that if it is conferring power to change primary legislation, it will require, constitutionally back to itself, the ability to scrutinise pursuant to the more intensive process that is required. Yeah. And so we respectfully submit that there is nothing in the repeated references to it being a Henry VIII clause. True it is. It's a Henry VIII clause, but it's a Henry VIII clause that Parliament has chosen to confer. And for good measure, as called for, whether it does so uniquely in this case or in the ordinary run of cases or always, has said it would like to have the benefit of having the affirmative resolution procedure intensive scrutiny.
Is there any authority for the proposition that a power to institute secondary legislation is to be construed more widely if it's subject to affirmative resolution rather than subject to negative resolution?
My Lord, I'm not aware of any, but my submission is that
I see
the force of the point in principle.
I see how it has some force. I just wondered if there was any.
I mean, Lord Donaldson covered both, whether subject to the negative or affirmative resolution procedure, subject to much briefer, if any, examination by Parliament and can't be amended, except, of course, if any doubt about its scope, the power, it should be resolved by a restrictive approach. That's
Correct.
in Spathome, approved by Lord Bingham. I know the reality is, I think the speech by Lord Judge, which is in the paper somewhere, although I haven't actually looked at it, I'm told it says that hundreds of thousands of statutory instruments have been passed and only 17 have ever been denied approval.
You would say we're getting into Article 9 territory.
I'd say we're getting into Article 9 territory in parliamentary procedures, but I'd also say that it depends what inference you draw from that statistic, if accurate. Yeah. One possible inference is that the legislation has been so obviously necessary and properly prepared that Parliament hasn't seen fit to, or any need to intervene.
And you say Article 9 requires us to assume that's right, Lily?
Yes, quite.
Yep.
One needs to be a little careful before drawing too much from numbers. I mean, I know that it's a vexed subject. I know it's a current hot topic, and that's no doubt.
How is it consistent with the Bill of Rights to strike down subordinate legislation which has been through the affirmative resolution procedure at all? Isn't one questioning what's...
The negative resolution procedure.
Isn't one actually questioning what's said in Parliament? But anyway...
My Lord, I'm not sure I'm going to answer that question if I'm allowed not to. But other than to say that I don't make that submission.
No.
I'm not taking a point on this court's power to do that. It's pretty well established. The principle of legality, if I may,
Have a decision that we can't. Yes.
We've cited the divisional court in the Gould case. I'm going to go to Ahmed rather than going to that,
Okay.
if I may. But can I just invite you to note that? It's paragraph 48 of Gould, bundle 7, tab 65, 5667 is para 48 of that decision.
Yeah.
But I do want to go to Ahmed because my learned friend founded on quite a lot on Ahmed and said that the principle of legality is engaged whenever, as he put it, any rights are interfered with. Of course, just before going to Ahmed, you will note that no application of the principle of legality has been cited to you in which there was anything other than a pretty serious interference with a basic constitutional right recognised by the common law, Ahmed, or in which human rights had been overridden. And we are not in that territory. We're not in either bit of territory. We're not in the common law bit, because unless you overrule Witham, which you're not being invited to do, there is no right at common law to legal aid. And you're not in ECHR territory because Section 10 exists.
You've taken us to that section.
And I've taken you to that. So we're just simply not in that territory. And there may be a debate, which perhaps isn't for today, because even if, and I'm not sure I'd necessarily quibble with this proposition, it might be thought to be, careful,
Don't worry. Yep.
didn't want to breathe in case it went.
Couldn't have done
might
that
be thought
if
to
I'd
be
tried.
Might be thought to be tolerably self-evident that there will be questions of degree involved, as my lady pointed out in Salim. The greater the interference, the more basic the right, the more acknowledged, the more the piece of legislation impinges, the more likely it is that something like the principle of legality will be engaged so as to constrain general words being used for that purpose. But Ahmed, we respectfully submit, does not properly advance my learned friend's case, which is to say, whenever you interfere, whenever anything is in play, whenever you're dealing with, appears to be the implication, Article 6 matters or court matters or justice, whenever you're in that territory, the principle of legality applies. That is not, we respectfully submit, the principle, and it is not the principle that the Supreme Court espoused in Ahmed. Can I just invite you to take it up again? Bundle 6, tab 57. It starts on electronic 5299. And my submission is that what the Supreme Court did in this case, and they didn't need to get into these subtleties between interference and incompatibility, because they were dealing with what they considered to be a very serious encroachment into a clearly recognised basic common law. But the suggestion that whenever human rights are in play or in the territory, we respectfully submit would be wholly unwarranted on the back of this decision. Lord Hope, first of all, my learned friend, I think, took you to 45, where he cites Lord Hoffman from Sims. But you also need to read, if you're taking Lord Hope's judgment fairly, you also need to read paragraph 61.
Of Lord Hope.
Of Lord Hope, on page 5396. And the reason I go there is because what he does is to repeat and adopt what Lord Hoffman had said in Sims itself.
Oh, yes.
Fundamental rights cannot be overridden, and we would underline overridden, by general or ambiguous words, and for good measure, in 76...
Well, wait a minute. You've now, between you, you've taken us both of you to 61.
Oh, well, I apologise.
Well, it's not your fault. You're right, if I may say so. But look at the difference, if there is one, between adversely affect in line 4 and overridden in line 8 or 9.
Yes, but it may be that...
Is there a significant difference?
Well, I'm not sure there is, in truth, and I'm not sure he's trying to draw that. It may be that that's explicable by reference to the context, because adversely affecting a basic right appears to be a reference to the basic right at common law to go about, carry on your business or to deal with your own property.
Well, overridden is Lord Hoffman's word.
Overridden is the ECHR one.
It's also Lord Hoffman's word.
Yes.
Sims. Adversely affect is Lord Hope's word in this case, yes?
Adversely affected and then overridden.
Yes, all right.
It's both.
To add to this, but both at common law and under the European Convention, the liberty of the subject can only be removed by Parliament.
Yes.
And if you're asking whether Parliament, by general words, has delegated that power, it's highly implausible
Right.
it will have done.
Quite, and that's why I've spent so long in this case on Section 10 and all of that.
Okay, well, there isn't any.
There isn't any. We're dealing with the removal of a non-obligatory state subsidy
Yes.
for residents.
Right.
And if you've got the parallel, I'm not going to go into question 2, but if you've got the parallel with state subsidy, all the courts below, including the divisional court, said, well, no difficulty under the convention. Residents, the connection that residents provide is a well-established, well-recognised mechanism for differentiating in relation to the provision of state subsidy. And once you strip out, as Section 10 requires you to do, the justice elements, if I can put it that way, the concerns that those who are really in need will not be able to get into court, then you are genuinely then dealing only with that sort of thing. But just on the test, and again, without wishing to be too linguistic about Lord Hope's judgment, but if you go forward to 76, he accepts Mr. Rabinder Singh's proposition that as fundamental rights may not be overridden, you see that at the bottom of 5401, and then over the page, Section 1 of the Act doesn't give authority for overriding the fundamental rights of the individual.
This was Article 8, was it?
This will have been
Oh, and
Article 8
A1,
under A1P1.
and A1P1, but they're both qualified rights, of course.
Yeah. Yeah. But you'll also bear in mind from this judgment, in terms of the very different context of this case, it isn't just the nature of the right, the nature of the interference, and the fact that he keeps referring to overriding, which is the Hoffman formulation in Sims.
Yes.
But when you get to paragraph 80, you will see that the fundamental problem, look at the last 2 or 3 sentences between F and G of paragraph 80, the essential point that Mr. Singh makes is that G ought not to have been subjected to this by an order made on Section 1 which avoids parliamentary scrutiny. Yes. This is the fundamental objection. So we're back to that. That's the problem. And that's what underpins the principle of legality. Do not override fundamental rights without taking the political heat. If you're going to do that, then you need clear and express authority from Parliament, and you need to put it squarely to them, and et cetera, et cetera, et cetera. But the problem here was that the ordering council that was being made didn't have any parliamentary scrutiny attached to it at all. But just on the basis of the test, again, various different language being used, but be very careful about Mr. Fordham's alighting on the language that serves his case forensically. If you look at Lord Phillips, for example, he uses the word encroachment in 111.
Yes.
But he does so before immediately going on to cite Lord Hoffman in Sims, with its reference to overridden. And you see the way he puts it at the back end of 122 on page 5414. Last sentence of that, between A and B. In order to avoid interference with individual rights, that is not proportionate. So again, it's a kind of muddle up of para 1 and para 2 of the qualified articles, if those are in play as they are in A1, P1 and Article 8. And it's against that context, if you're going to alight on 138 and say in play and start drawing lines under in play, it needs to be read in the context of the judgment. And 154, just to complete Lord Phillips, seriously interfered. You go into Lord Roger at
I don't think, I mean, are you suggesting that in Ahmed the court was deciding that the legislation involved a breach of the relevant articles of the European Convention on Human Rights? No, you're not, because I mean, it plainly didn't. I think we left
it
it.
because of Al Jeddah.
Yes, and I think we left all that to primary legislation. The court was effectively saying, if you're going to have a judgment as to what is appropriate by way of deprivation of liberty, it's one which Parliament makes, not a subordinate delegated legislator.
My lord, yes. I mean, I'm not quibbling with that at all. What I quibble with is the idea that as long as you can identify a human right in play,
yes,
or being interfered with, yes, then suddenly the principle of legality is engaged. The human right is in play in almost every species of legislation.
You say it's a deprivation of fundamental right.
I say it's overriding. Go back to Lord Hoffman.
Yeah.
Overriding, and for good measure, I won't go through it laboriously, but Lord Hoffman was cited, quoted, and relied upon by all of...
That's Lord Hoffman and Sims in each...
Lord Hoffman and Sims. Lord Roger at 185, okay, Lord Mance at 240, Lord Brown at 193. And we respectfully submit that that gives you the flavour. I mean, it may or may not go quite as far as saying incompatibilities. It may not be a direct echo of Section 3 of the Human Rights Act and what is required to trigger a possible interpretation, which undoubtedly is incompatibility, to avoid incompatibility. But what you cannot do is simply turn up and say, well, we're dealing with a bit of justice here and there, and therefore you need to apply the principle of legality. And even if, therefore, there is scope for questions of degree involved, we respectfully submit that Section 10 lies at the heart of it and is thoroughly important. So that's the second submission, no constitutional reason for giving the language anything other than its natural reach. The third submission is really a responsive one, which is that my learned friend asserts that Parliament in LASPO has considered the classes of greatest need. And again, I've touched on that already quite a bit, so I can take that tolerably quickly. I submit that it's not enough to say that Schedule 1 as currently set up is by reference to, even if that's accurate, perceived needs of those involved in the subject matter that is covered currently by Schedule 1. And the reason, just to develop that a bit, the reason that Lord Justice Laws said at paragraph 21 that need and cost are not strange bedfellows is because the reason that my learned friend Mr. Fordham focuses on need is to exclude any change based in part or in whole on streamlining, making more efficient and saving money, targeting it at those with the strongest connection. He has to say that those purposes are outside the relevant statutory purposes, and he can only do that if he says it's need and need alone. Once you acknowledge that need and cost are not strange bedfellows, and you follow the logic of Lord Justice Laws through thereafter, it becomes entirely clear that that isn't the position. And moreover, the point I debated with my Lord Reid a moment ago, my submission is that present setup does not lead to an inference or an implication of future constraint. It might be thought that one can ask a rhetorical question at least, which is why would Parliament effectively remove cost or the size of the public resource pot for funding these non-obligatory cases? Why would it want to remove that as being relevant to the consideration of the exercise of the power under 9.2? I'm assuming for this purpose that there is no linguistic problem that excludes me from the reach of 9.2. So we're here on pure purpose. But once you acknowledge that the natural meaning does indeed, when properly construed, cover that situation, why on earth would Parliament want to restrict itself in that way? And Parliament could decide, under 9.2 on that basis, to cut out a vulnerable category. So it could decide, as appears to be common ground, that although one of the categories in Schedule 1 was thoroughly deserving on its face, that could be omitted. No one quibbles with that possibility. You can omit a category without demonstrating any particular motive or reason. And so what you're then left with saying is, well, although you could strip out some thoroughly deserving category in Schedule 1, Part 1 entirely, you can't take the lesser step of varying it so that it only applies to certain categories of person or a certain class of person, namely those who are resident. But that would be to run an argument that permits the greater and then sets one's face against the latter, swallowing gnats and camels. And I do respectfully submit also that the reason for the omission or variation, subject to the statutory language, is irrelevant to vires. There's nothing in 9.2 to suggest such a limitation. You can only omit if it's no longer necessary because of greatest need. How would that work?
Well, presumably all these things would be subject to judicial review. So one would see under the duty of candour the material on which they'd based the decision, and one would be able to evaluate it. So I imagine we'd just be arguing actually the same point in a different guise.
Yes, but what I meant by how would it work is, what if there was a mixed purpose?
Yes.
I don't, of course, dispute that a duty of candour would require us to produce the documents that showed why it was done, but it may be jolly difficult to find out if it's affirmative resolution procedure. Someone might stand up, the minister might stand up presenting this, saying, I regard this as being a thoroughly important change to be made because I don't really regard there as being, on reflection, a real need for this category. And then the majority, all the speakers thereafter, during the affirmative resolution debates, then say, well, that's all jolly interesting, but we think that public resources are deeply stretched, and therefore it's cost. Then they vote, and the measure gets passed. What then? How do you deal with mixed motive, mixed reason?
That does get us back into the question of what one could look at.
Yes.
Is there a problem that the court is being asked to look at this in draft before Parliament has looked at it? I mean, I'm not suggesting there is, but I'm just, or submission make me wonder it. I mean, it would be, one wouldn't expect a court to rule on the compatibility of a bill with the European Convention. One would, I think, wait and see what was in the Act. But then this is rather different because this is essentially a question of construction of the Act. And one can say, well, we are actually simply construing an Act which has been passed rather than pontificating about a potential Act. Is the consequence of that there's no problem us looking at the legality of something which is at the moment waiting to be considered by Parliament?
My Lord, I don't take a point that this is a premature claim.
Right.
It's secondary legislation. We had a flirtation with that below, but we're not flirting with it any longer.
Right.
There is some pretty clear authority that you can have a crack at secondary legislation of this kind, even in advance, and so
Yes.
we're not taking that point. But the point that I was on was rather a point of principle.
Yes.
About the scope of the power itself in the primary legislation, because I come back to it, as Lord Justice Laws rightly recognised, I think it was in para 23, on my learned friend's case at this point, you are otherwise within, there isn't any linguistic problem with being within, but he says you need to impose need as an additional constraint, and if you do that, my rhetorical question is, how does that work? Not in terms of the documentation you can look at, but in terms of where you have mixed motives and how that goes to work.
I think from recollection that when we heard Bank Mellot, I think we took the view that in our judgments, that was an executive measure, notwithstanding that it was approved by Parliament. And the relevant reasoning was the reasoning of the minister who explained to Parliament what the object of the measure was.
Yes. I mean, there might be a genuine and live issue about that sort of point when one gets to, I say when rather optimistically, when one gets to issue 2, because, as you know, ordinarily it is a factor that affects proportionality and margin that the issue has been considered. And again, in another context, I think in MA and Rutherford recently, we had the debate about what precisely that involved. And we know, post-Animal Defenders in the UK, that doesn't involve going in and querying Article 9 of the Bill of Rights, apart from anything else, the goodness, badness or indifference of the reasoning deployed by various members of Parliament in debate. What it does, as it were, is impose a constitutional factor going to restraint or to respect. So the final point in relation to this on need, and whether or not the legislation contains that sort of constraint. Again, as noted by Lord Justice Laws, we respectfully submit correctly at para 22, my learned friend accepted, and no doubt continues to accept, that you could delete on cost grounds classes of recipient having the least need. And he had to do so in order to avoid absurdity. But in order to do that, as Lord Justice Laws then goes on to point out, you've then got to start ranking categories based on need, and then only when you come in and you knock off the bottom one can you get that. That isn't the way the legislation works at all. And there's no indication in the legislation that it is meant to work in that way. So we do respectfully recommend the reasoning and the logic of Lord Justice Laws at para 22.
But I mean, the answer to that may be that if it's impossible to rank them, then it would be impossible to challenge the Secretary of State's judgment as to which to remove. That would be classically a judgment that he could make as to what, bearing in mind the hardship, the advantages, the cost saving, which was the least needy in terms of the statute to receive support.
But bear in mind the nature of the concession that is recorded in para 22. It isn't just that you rank them in order of need and then you knock off the bottom one. It is that you could knock off the bottom one, taking into account, or some of them, taking into account cost grounds. But once you accept that you can do it for that purpose, where then is the principled line to be drawn? How then do you hold the boundary?
Well, you require that the exercise is conducted by reference to categories that are defined by way of need, rather than to categories that are defined by reference to something else.
By reference to cost?
No. Cost is a factor in the decision that you make about a category defined by reference to need.
My Lord, sorry, I misunderstood, but I entirely see that. But you're still dragging in as relevant.
I follow that.
If only as enabling you to make the tie-break selection. The factor of cost. And if you can take it into account for that purpose, why can't you take it into account for other purposes?
Yeah.
Is the argument. Fourth point, I'm jolly nearly done. In any event, we do respectfully submit that the references to need and the fact that this is the sole ground on the basis of which this legislation was set up is not an accurate or fair characterisation of the purposes of the legislation in fact. We start with the warning of Lord Bingham based on Lord Diplock and Lord Simon in Sparth Home about the dangers of making too ready and glib an assumption that legislation which appears to be designed to cover a tolerably broad field is there solely for a single purpose. And we respectfully submit that that applies just as much to this legislation. The whole purpose of the legislation is to set the structures by which civil legal aid is provided, to provide the primary legislative structures to indicate who takes the decisions in individual cases, the director, how that's to be done, to draw the lines between primary and secondary. But all of those policy issues, all of those features in determining what that structure should be, are determined, and it is relevant to take into account, we submit under that scheme, not simply the narrow category of need, but also the broader purposes that Parliament evidently considered and evidently had in mind when making decisions, including specifically about Schedule 1. It's a constant theme of all the pre-legislative materials, and there's nothing in the primary legislation to indicate to the contrary, that there is indeed truth in Lord Justice Laws's statement that need and cost are not strange bedfellows. Any provision of non-obligatory legal aid inevitably involves judgments having to be made, decisions having to be made on the essentially political issue of how taxpayers' money should be spent. And indeed, what does need mean? Is it most deserving? Is that a relative concept? Is it need subject to what we can afford? It can't be open. And on that basis, we submit that not merely do those themes, all of those themes flow through this legislation self-evidently, but it's also pretty clear that Parliament was not setting its face against the 45 categories originally introduced in Schedule 1 being the be-all and end-all. Whatever its true scope, they envisaged it being changed. Why on earth would Parliament want to cut out considerations, which are no doubt obviously close to its heart, of whether the state can afford things and how they can afford things? I mean, one can put that positively by saying focus on ad services in 9.2. What happens if we have boom economy and public resources flushed? Pretty difficult to envisage those times, but assume that that is the position. Could one say, well, I don't regard there as being any great change in categories of need, but now we're richer, we can afford more. If that works for adding, it must work for omitting. It's exactly the same power. And the background materials, again, I'm not going to take up time with it, but the background materials, I may just give you some references, if I may, demonstrate completely clearly that the aims of LASPO were not restricted to the need, to the exclusion of those sorts of broader issues around focusing on legal aid in time of stringency, focusing and targeting legal aid in time of stringency.
That doesn't necessarily address the fundamental point being made, that it's the class of people who have the same need as another class of people, does it? In other words, you are excluding people who may have equally identical claims from getting legal aid when another class of person in exactly the same position otherwise does get legal aid.
That is true.
The cost point doesn't really meet that, does it?
The cost point doesn't meet that, but it does illustrate that it isn't just solely need. You can make decisions about whether and how you change Schedule 1 by reference to other factors apart from purely that. And my Lord is right, of course, but that's no more than to say that you're dealing here with setting the boundaries for the provision of legal aid.
Yes, but it's a question of in what dimension, as it were, you can set the boundaries.
It is, but you've got a bright line anyway by reference to Schedule 1, and the question is it acceptable to set other bright lines in deciding what the scope of that non-obligatory legal aid should be?
Yes, I see.
And in relation to that question,
yeah,
to address the case that's been made throughout and continues to be made, as I understand it, my learned friend's case is you cannot take into account, it is inconsistent with the statutory purpose and therefore Padfield breaching.
yep.
You cannot take into account anything other than need. So the only way in which you could change Schedule 1 would be by reference to need alone. You couldn't say.
Well, need, importance and means, those were three criteria, I think.
It's almost type of service rather than need, isn't it?
Yes.
need undoubtedly must have dictated what Parliament chose to put into Schedule 1 by way of type of service, which ones got in and which ones didn't,
Yeah.
all of which was quite controversial, but that's irrelevant. But it's actually not so much ranking of need, is it? It's a question of whether you define your class in terms of service or in terms of some other
Yes.
quality.
As I put it earlier on, the
Yes.
mechanism that you use
Precisely.
to select
Yes.
what happens in Schedule 1. And that's why I was emphasising you have subject matter, you have nature of service, and the question is, can you have other matters that feed into that, including in non-obligatory legal aid, close connection to this country through residence. And my respectful submission is that that isn't a radical way of doing things in the context. Once you appreciate that we're dealing with non-obligatory legal aid, you are dealing with public subsidy for those types of cases. Residence is a pretty well-established way of controlling those to whom public subsidies are given and those...
Yes, it is, but we're not on at the moment the question of whether it's justifiable.
No, we're not.
We're on the question of whether it's within the Act.
We are, but the reason we're drifting into that sort of debate is because the sharper, if I can put it loosely, the injustice of the case that my learned friend can make, the less likely it is that you will be persuaded to give the words their natural meaning. That's the entire thrust of his case on ultra vires.
Well, no, that's not right, is it? The fact that it may be sufficiently unjust for him to be able to mount the second argument is ultimately incidental. The question is, can you do this as a matter of construction, whether it would be otherwise objective?
Well, that's certainly true.
That carry the day, or may not carry the day.
Sorry, my lord.
Not in the end necessarily the jury points that may carry the day.
No, totally. Which is why I spent a bit of time at the beginning trying to deal with the linguistic arguments and how the structure of the Act worked. Yeah. But quite a significant part of my lady friend's case was based on the principle of legality, and you shouldn't give the words their natural breadth because... And in my submission, he does have to go there. He recognises rightly that he has to go there because the words are naturally broad. And unless you can introduce some limitation that says class of person means class of person defined by reference to need, he's in trouble. And the way he does that is to place reliance on the Henry VIII clause and principle of legality. My lord, I won't take long on the... you've seen most of the quotes from the Court of Appeal's judgment and indeed to some extent from the Divisional Court judgment, although they did develop a bit of a habit of quoting from some of the pre-legislative materials whilst leaving out sentences or bullet points. But the broad thrust of LASPO and what it was designed to do was to allow for all of those features, including need, but also cost and targeting and efficiency and all of that. Those are all in play in the pre-legislative materials, properly and fairly read. So if you go, for example, to the 2010 consultation paper at Appendix 2A, sorry, just quickly, starts at MS 200.
Yeah.
You see that...
Which page do you want?
I want 232 particularly.
Thank you. Yep.
But again, it's all pretty much for the same point. It's this reference to, in the light of financial constraints, we've got financial stringency, we're trying to tighten it up, we're deliberately narrowing on cost grounds the scope of legal aid and its availability because it's £2 billion and we can't afford that, and so on. So one sees that from, for example, 4.1,
Yep.
4.3, 4.4,
Right. Yep.
4.11.
Yep.
And then the range of factors that have fed into the design of the legislation in 4.12 which are then picked up on and expanded in the remainder of that section of the consultation paper. And then you see the conclusion, taking all of those into account at 4.28 and 4.29. So need simply doesn't cover neatly or at all the reality of what this Act was designed to do.
Yeah, I understand.
And then the consultation response from the government, which preceded directly the introduction of the legislation, 2011, that starts on page 517 in the same bundle. And you get it, I think, from a passage that my learned friend referred you to this morning, 520, the first paragraph.
Yeah, we looked at that.
But then in particular, if you wanted one paragraph that summarised the broad aims,
Page?
524, paragraph 10,
Yes. Right.
and you will recall that the divisional court, I say even the divisional court, at paragraph 44, accepted that if I am right about the broader purpose of this legislation with these other themes in play, including prioritising public funds in times of real financial stringency and so on, then their analysis on varies would have necessarily have been different. See paragraph 44 of their judgment. And we know what the Court of Appeal concluded on this issue as well. Yep. My Lords, my Lady, for all of those reasons, we do respectfully submit that the Court of Appeal's reasoning and conclusion on varies was correct. There isn't any linguistic or pure interpretive way out based on the concept of services in section 9.2. And in order to meet the case that my learned friend has made directly through all this litigation about the underlying purposes, they are broader than he asserts, as the Court of Appeal correctly found. And there isn't, assuming, which would have to be the premise for this, that he doesn't succeed in persuading you about the linguistic points. I do then submit that the Court of Appeal's reasoning was entirely correct on purpose.
Thank you very much, Mr. Feversham. Thank you. Mr. Goodall.
My Lord, my Lady, just a few points in reply.
Yes, of course.
We have never said it is need and need alone, and nor did the Divisional Court. They quoted the passage that talked about with a view to saving public funds. We don't have a problem with the bedfellows the Court of Appeal described. We recognise you can prioritise. They did prioritise with a view to saving funds, and you could reprioritise. It's the saving of public funds by targeting priority need, or it is targeting priority need with a view to saving funds. And Mr. Eadie has to strip out the targeting of priority needs, because the problem is not that cost can be relevant and you could reprioritise if there were further budgetary constraints, or in a time of great state affluence, add something back in that missed out when you were making the cut. The problem is he needs to be able to say the varies extends to introducing some factor that is wholly extraneous to need. That's never been done. He hasn't taken you to a single example in the structure of Schedule 1 that involves any extraneous factor. He hasn't taken you to a single change in Schedule 1. There have been plenty of changes made to it that involves any of that. In the end, we submit he can't answer the point that the scheme, the plan, the legislative plan, as the Australian eggs case had it, is very clearly needs-based. If you want to say that's service, the meaning of service, because it's the substance of a service, it's the needed service, it's the needy class, it's the same point. The boundary that he says can't be held has been held, there's no example of any differentiation like this from start to finish. He doesn't submit that Henry VIII powers can extend the object and purpose. And he's right not to make that submission. So if the object and purpose that we can discern is targeting greatest need or priority need, brackets with a view to saving public funds, that's the end of the case, because a Henry VIII power cannot...
If one category in Part 1 of Schedule 1 proved to be become quite enormously expensive, would the Secretary of State be entitled to say, we simply can't afford that category anymore? Litigants in that category will have to find other ways of dealing with their position, whether it's private insurance or whatever, making better use of such conditional fee arrangements as are possible and so on. But they will simply have to forego legal aid. Would you be able to challenge that on the grounds that...
Yes, I would. My answer is no, but it doesn't matter. My answer is no, you couldn't do that. And in all, we've seen the analysis. We've got 500 pages of documents on LASPO. There is not one example of a decision that says, well, something's more expensive than something else, but there's more of a need, but nevertheless we're going to relegate it. They identify 4 objective factors, and they identify priority need on that basis. And cost doesn't come in to rank something that wouldn't otherwise be a priority because of cost. So I could challenge that, and I don't accept that that can be done. But it doesn't matter, because even if one could take cost and balance it against need and say this is the step that we're going to take having put the 2 bedfellows together, that wouldn't go far enough to be able to bring in something that is extraneous to need, and for that matter to cost. The 2 people side by side, the children in the class with the special educational needs, same costs, same merit and means, and so on and so forth. Mr. Eadie says, well, it would be odd if you couldn't take what he calls the lesser step. I understood him to call it the gnat as opposed to the camel, where, yes, you can take a whole category out, but you can't take it out for a group. We respectfully submit it's impossible to see that as a lesser step. That is the more invidious, precisely because in the context of these priority areas, it takes 2 people, as you're in the same position, but we're going to knock one of you out. The same position so far as need is concerned. And from Kamwaja to Belmarsh to all the cases that say, well, you can make choices, but what you don't do is discriminate between people who are in the position. And if we're right, so far as the needs point is concerned, that's the end of the case. Now, Section 11, Mr. Eadie expressly accepts that Section 11 could not be used to introduce that kind of test, a test that took same position, people in the same needs position and differentiated between them. And yet, Section 11 allows a criterion to be identified by the Lord Chancellor, in addition to the criteria, the factors that are stated in Section 11. It's expressed as a broad power. It's read with Section 41(2)(b). It's the subject of affirmative resolution, regulations under Section 11. Why is it that he rightly accepts that you couldn't introduce that kind of distinction? It's because you have to start by understanding the scheme, the plan, the design, the pointers as he described them. But that's exactly the argument that we have so far as Section 9 is concerned, once one understands the scheme, the plan, the object, the purpose. He didn't go anywhere near rights of women in Section 12, but you'll recall we saw that very point. Section 12 regulations can't be used to frustrate the statutory purpose. What was the statutory purpose? It was needs-based in the design of legal aid. You can't introduce something extraneous in Section 12 regulations. You can't do it in Section 11 regulations, as he accepts, and you can't do it in the Section 9 Henry VIII clause by the same logic. He says Section 10 is relevant because that's the essential cases, and the essential cases are already dealt with. We leave aside the realities of Section 10 and how it's been found wanting in relation to the implications for those it affects, but there's an authority on it in the bundle. It's a case called S in the High Court, and it's tab 60 in volume 7. What you saw from Gudanavikien, and I just want to give you a couple of other references, is there is a protection by reference to EU law and ECHR Article 6.
Yeah.
But if you look at paragraph 38 of Gudanavikien and paragraph 38 and 58, you'll see that that is a protection that is designed to protect what's called the very core of the right of access to justice. It's page 5758, bottom 12 lines of the page in the DEB case, and it's paragraph 38 where one has, just above letter F at page 5752, the essence of the right of access to the court. What it comes to is restriction of the right of access to the court through the absence of legal aid only involves a breach of Article 6 where the very core of the right is undermined. And that's the protection, the safety net of Section 10. Important as that is, that leaves all the other cases within these pressing legal aid areas, these targeted priority need areas where these 4 objective factors were used to assess those cases that should be within scope as a matter of priority. And unless they can establish that the very core of the right of access to the court is undermined, Section 10 will not avail them. Were it otherwise, it would be irrelevant to be changing the scope of Schedule 1 and pressing need, because everyone would benefit immediately under Section 10. And of course, that's not remotely going to be the reality. The Court of Appeal, and I started with this, recognised that cutting further back on Schedule 1 on the basis of need was something extremely difficult, humanely and rationally, to do. This is not new that legal aid be focused on priority need. You asked Mr. Eady, could he point to an example of a restriction of this kind, a residence test of this kind, or any restriction of this kind? There is not one single example in the history of legal aid that he can point to that would draw that kind of invidious distinction. And targeting priority need goes back to before the 1999 Act. The authority for that you'll find in the bundle at page 5952, the case you heard of Lawrence and Fenn Tigers. It's paragraph 26, and you describe in Lawrence and Fenn Tigers the rationale prior to the 1999 Act, the predecessor to LASPO. What was it doing? It was prioritising on the basis of need, and it has always been thus, which is why this case and this proposed measure is completely out of step with anything that would have been anticipated or acknowledged in the language of Section 9, in a Henry VIII provision that is supposed to be restrictive and narrow, which is how it was described, and he's got no answer to that, and therefore in relation to the provision that's been relied on. More than one objective and spath home takes him nowhere, because we have got the unifying purpose, and it's the same one that the Court of Appeal recognised in the Rights of Women case. Lord Bingham found more than one purpose for Section 31. Is there something extraneous to need that you can find within Schedule 1? Well, if there is, you haven't been shown it. You haven't been shown what provision reflects it, and you haven't been shown what it is. All that we've got is, with a view to saving public funds, targeting priority need. The point about healthcare and residence tests, you haven't been given any examples where it's other than primary legislation that draws lines of this kind, even in the context of health and welfare. But lest, we didn't get to this because it's part of the other point, but lest you be equating or tempted to equate legal aid with a welfare benefit, can I just remind you of what Dr. Cohn a long time ago recognised in relation to legal aid, and you'll find it in the bundles, My Lady Hale at 6798 and 6856, and Lord Bingham at 7571. Legal aid is not to be equated to benefits of those kinds. It is far more important, and in this case, the relevant benefits have already been conferred because all the relevant people who are affected by Schedule 1 priority areas have had those rights conferred on them, including by welfare benefits provisions, where Parliament has decided that those rights apply to them. That is the platform on which this case stands. Finally, my lords, my lady, the principle of legality. Mr. Eadie's problem is that Ahmed was not an abrogation case. There is no finding anywhere that there was abrogation of rights, nor was it a deprivation of liberty case. If you look at paragraph 91 in Lord Phillips, he recognises what the argument about abrogation was. It was Article 8 and Article 1, A1P1, both qualified rights. The court didn't get there. The language of interference was Lord Brown-Wilkinson in the Pearson case, and you'll find it in Ahmed at paragraph 46. When you look at the language of the speeches, I'm not going to go back through the passages I gave you, when you look at the ratio of the case, this is inconsistent with the principle of legality and therefore unlawful. And when you look at the absence of any finding of abrogation in that case, it is very, very clear that the principle of legality does not require an abrogation. Mr. Eadie says, well, a bit of justice here or there, or whenever rights are in play, or whenever you're in the territory of rights. None of that was my argument. And I specifically drew to your attention and accepted the way in which the point had been put by my Lady Hale, and it's in the Salim case at 6803. You look at the importance of the right, you look at the nature of the interference, and here a very significant interference with a right of equal protection of the law. Equal protection of the law is not limited to there being equal law. Equal protection of the law is engaged where there is the treatment of people who are relevantly, identically placed, and a group is taken and treated differently. And that's precisely what's in play here. Before you get anywhere near justification, for that reason as well, one cannot exercise this Henry VIII power to redesign this statutory scheme, to introduce for the first time in history an extraneous factor that has nothing to do with the cardinal principles of merits and means and needed services. Unless I can assist you further, those are our submissions in reply.
Thank you very much indeed. I think that concludes the argument on the first point. I think give us a few minutes and we'll see where we go from here.
Thank you, my lord.
We'll rise now and I hope we can come back within 5 minutes. Court will adjourn.
Court will rise.
We propose to allow the appeal on the first point, and at the moment, the ultra vires point, and at the moment we are disinclined to consider the second point, the discrimination point, but we feel it's right that you should have an opportunity to persuade us otherwise if there's any reason we should consider it. If that puts you in a difficulty and you wish to take instructions and come back tomorrow morning, while that will obviously increase the costs, it may be only fair to permit you to do that if there's a good reason. But we would rather decide this evening so everybody knows where they are. And if what we, at the moment, would propose to do it will save the cost of tomorrow altogether.
My lords, my lady, thank you very much. Our position is that we're not going to ask you to come back tomorrow for either purpose, hearing us or hearing us on whether to hear us.
Thank you.
What we would like to reflect on is what order might be appropriate.
Well, that you can see that.
What we've got in mind is that suppose there were to be a decision to proceed with primary legislation, but exactly the same design. We're a charity. It would be completely pointless to go back through the lower courts in relation to an issue that's already been decided against us by the court.
So you might propose we adjourn.
That might be a sensible solution with liberty to restore.
I think that sort of point can be dealt with
yes,
when
exactly
you get the
right.
judgment, but it's very fair for you to
That's how
raise
we
that.
saw it, but that's the only thing that's in our mind.
It hadn't occurred to me. It's a fair point. Thank you very much.
Thank you, my lord.
Thank you. Mr. Eading.
Well, I think I'm going to need to take instructions, but if the answer is that we don't propose to invite you to hear us tomorrow morning, then can we notify...
Yes, that's a very good idea.
Save everyone the trouble.
Yes.
Obviously, notify my friend.
Yes. If you and he can agree that it's unnecessary for you to come tomorrow, that's fine. And the difficulty is not primarily for us because we're here. The difficulty is more for the advocates and instructing solicitors and so on. So that
I'll take some instructions.
Obviously, if you can let
quickly as I
everyone
can.
know this evening, that would be that would be good. But that's a fair request.
And obviously any form of order will need to be thought about in the light of your judgment.
Yes, and as to whether the second point should be adjourned or what should be dealt with it, that's something which you and Mr. Fordham can consider, and if you can't agree, you can make submissions on it after we've made the draft judgment available. Thank you very much indeed. Thank you both for a very well argued case today. Thank you. Sorry. Yes. Thank you very much. Court's now adjourned.